What is the difference between a living will and a living trust?
Well, a lot. Okay, so a living will addresses circumstances when you are dying, right? So you no longer have, you're in permanently unconscious, persistent vegetative state. You show no behavioral responses to your environment, and your doctor says you are dying. That's what a living will is for.
Okay.
A living trust is a document that you create while you're living, and it's where you put your assets and you manage your assets, right? So they are very, very different documents. They do incredibly different things. And a living trust in no way really addresses, you know, if you want to be put on life support or not. Okay. So that's what.
But interestingly, the parallel between the question regarding conservatorships and the two different types, conservator of estate, and which deals with financial issues, and conservator person, that those documents kind of fall in those same categories.
Yes.
That the living will falls under the medical decision making, and the
Financial.
The living trust falls under the financial. Because one of the really nice things about revocable living trusts is, and it's a document that is typically put in place to take the place of a will. And so one of the primary reasons why people do revocable living trusts is to avoid probate. Because if at your death, your assets that would otherwise be probate assets, and a probate asset is a solely owned asset with no beneficiary designation on it. At your death, no one, if you have a solely owned asset, like if I pass away and I have a bank account that's solely in my name, nobody has the legal authority to do anything with that. Well, the same thing with that bank account is that if I don't have any documents in place and I become incapacitated, nobody has any authority to do anything with that account. And so that's where a conservator would come into play. With a revocable living trust, not only can it help you to avoid probate and to distribute your assets at your death according to what your wishes were, but also in incapacity that you will have named someone who is called a successor trustee to step into your shoes and to manage your trust assets for you during your period of incapacity, whether it's temporary or permanent. If it's temporary, once it's been resolved and you regain capacity, that successor trustee can step out and you can get back to managing your own assets.
Do you create a living trust as well as in your practice?
Oh, yeah.
Absolutely.
We do it a lot.